39.
I propose the question that clause 38 and 39 be part of the bill. I put the question that clause 38 and 39 be part of the bill.
Clause 40.
I propose the question that clause 40 be part of the bill. Majority Leader.
Honorable Chairperson, I propose that clause 40 be amended as proposed.
I propose the question that clause 40 be amended as proposed. I put the question that clause 40 be amended as proposed. Division at the end.
Clauses 41 to 51.
I propose the question that clauses 41 to 51 be part of the bill. I put the question that clauses 41 to 51 be part of the bill. Division at the end.
New clause 8A.
Majority Leader.
Honorable Chairperson, I beg to move that the new clause 8A be now read a second time.
I propose the question that new clause 8A be now read a second time. I put the question that new clause 8A be now read a second time. Division at the end.
New clause 8B.
Majority Leader.
Honorable Chairperson, I beg to move that the new clause 8B be now read a second time.
I propose the question that new clause 8B be now read a second time. I put the question that new clause 8B be now read a second time. Division at the end.
New clause 8C.
Majority Leader.
Honorable Chairperson, I beg to move that new clause 8C be now read a second time.
I propose the question that new clause 8C be now read a second time. I put the question that new clause 8C be now read a second time. Division at the end.
The first schedule.
I propose the question that the first schedule be part of the bill. I put the question that the first schedule be part of the bill. Division at the end.
The second schedule.
I propose the question that the second schedule be part of the bill. Majority Leader.
Honorable Chairperson, I propose that the second schedule be amended as proposed.
I propose the question that the second schedule be amended as proposed. I put the question that the second schedule be amended as proposed. Division at the end.
The third schedule.
I propose the question that the third schedule be part of the bill. I put the question that the third schedule be part of the bill. Division at the end.
The question that the second
Clause
schedule
2.
be amended as
I
proposed.
propose the question that clause 2 be part of the bill. I put the question that clause 2 be part of the bill. Division at the end.
The title and clause 1.
I propose the question that the title and clause 1 be part of the bill. I put the question that the title and clause 1 be part of the bill. Division at the end.
The third schedule. I propose the question that the third schedule. I propose the question that the third schedule. I propose the question that the third.
Honorable Senators, we are now moving to the next order on the order paper.
I propose the question that the third. Honorable Senators, we are now moving to the next order. Honorable Senators, we are now moving to the next.
Okay, now we are moving to the National Construction Authority amendment. The National Construction Authority Amendment Bill, National Assembly Bills number 59 of 2022.
Majority Leader? No. Clause 2. I propose the question that clause 2 be part of the bill. I put the question that clause 2 be part of the bill. Division at the end.
New clause 1A.
New clause 1A. Majority Leader?
Oh, the other one is working. It's clause 1A. Yes. Honorable Chairperson, I propose that the new clause 1A be, wait. Yeah, it's actually, Ms. Honorable Chairperson, I propose that the new clause 1A be now read a second time.
I propose the question that new clause 1A be now read a second time. I put the question that new clause 1A be now read a second time, division at the end.
The title and clause 1.
I propose the question that the title and clause 1 be part of the bill. I put the question that the title and clause 1 be part of the bill. Honorable Senators, we are proceeding to the next bill, the Cancer Prevention and Control Amendment Bill number 2, Assembly Bills number 45 of 2022.
Clause 2.
I propose the question that clause 2 be part of the bill. Mover.
Is this one functioning? Okay. Mr. Speaker, that clause 2 of the bill be amended in the proposed new definition of the word e-health by inserting the words including telemedicine immediately after the words and information technology in quotes.
I propose the question that clause 2 be amended as proposed. I put the question that clause 2 be amended as proposed, division at the end.
Clauses 3 and 4.
I propose the question that clauses 3 and 4 be part of the bill. I put the question that clauses 3 and 4 be part of the bill, division at the end.
The title and clause 1.
I propose the question that the title and clause 1 be part of the bill. I put the question that the title and clause 1 be part of the bill, division at the end.
H. You need H. So we are not going to the
Honorable Senators, we proceed to order number 24. The Election Offences Amendment number 2 Bill, Senate Bills number 28 of 2024.
Clause 2.
I propose the question that clause 2 be part of the bill. Mover.
elections. No. That's number 24. No, I thought we had said
Honorable Chairperson, I propose that clause 2 be part of the bill.
I propose the question that clause 2 be amended as proposed. I put the question that clause 2 be amended as proposed, division at the end.
New clause 3.
Majority Leader.
Honorable Chairperson, I propose that the new clause 3 be now read a second time.
I propose the question that new clause 2 be now read a second 3. New clause 3 be now read a second time. I put the question that new clause 3 be now read a second time, division at the end.
New clause 4.
Majority Leader.
Honorable Chairperson, I beg to move, now read a second time.
I propose the question that new clause 4 be now read a second time. I put the question that new clause 4 be
number ambe. No, we'll start with the election amendment.
Did I contribute?
So, tumemaliza elections amendment.
We report progress, but we can't report to people. Sorry? Oh, yeah. Yes, let's do it. Okay. Proceed. Yeah.
I call upon them.
Yeah.
And he will talk to the speaker.
Sawa.
The Meteorological Bill, Senate Bills number 45, 2023. Majority Leader, move to report.
Honorable Chairperson, I beg to move that the committee do report to the Senate its consideration of the meteorology bill.
I put the question that the committee do report to the Senate its consideration of the Meteorological Bill, Senate Bills number 45 of 2023, and its approval thereof with amendments. As many as of that opinion say aye. Aye. As many as of the contrary opinion say nay. The ayes have it.
Because we haven't. Sorry. Honorable Chairperson, I beg to move. Honorable Chairperson, pursuant to Standing Order number 153, I beg to move that the Committee of the Whole do report to the Senate its consideration of Meteorology Bill, Senate Bill number 45 of 2023, and seek leave to sit again tomorrow.
Senators, I put the question that the Committee of the Whole do report to the Senate its consideration of the Meteorological Bill, Senate Bills number 45 of 2023, and seek leave to sit again tomorrow. As many as of that opinion say aye. Aye. As many as of the contrary opinion say nay. The ayes have it.
Yeah, that's okay now. The NCA one.
National Construction Authority Amendment Bill, National Assembly Bills number 59 of 2022. Mover.
Honorable Chairperson, pursuant to Standing Order number 153, I beg to move that the Committee of the Whole do report to the Senate its consideration of the National Construction Authority Amendment Bill, National Assembly Bill number 59 of 2022, and seek leave to sit again tomorrow.
I put the question that the Committee of the Whole do report to the Senate on its consideration of the National Construction Authority Amendment Bill, National Assembly Bills number 59 of 2022, and seek leave to sit again tomorrow. As many as of that opinion say aye. Aye. As many as of the contrary opinion say nay. The ayes have it. The Cancer Prevention and Control Amendments Bill number 2, Bill National Assembly Bills number 45 of 2022. Mover.
Mr. Speaker, Honorable Chair, pursuant to Standing Order 153, I beg to move that the Committee of the Whole do report on its consideration of the Cancer Prevention Bill and seek leave to sit again tomorrow.
I put the question that the Committee of the Whole do report to the Senate on its consideration of the Cancer Prevention and Control Amendments Bill, National Assembly Bills number 45 of 2022, and seek leave to sit again tomorrow. As many as of that opinion say aye. Aye. As many as of the contrary opinion say nay. The ayes have it. Honorable Senators, we move to the Election Offences Amendment Bill, Senate Bills number 28 of 2024. Mover.
Honorable Chairperson, pursuant to Standing Order number 153, I beg to move that the Committee of the Whole do report on its consideration of the Election Offences Amendment Bill, Senate Bill number 28 of 2024, and seek leave to sit again tomorrow.
I put the question that the Committee of the Whole do report on its consideration of the Election Offences Amendment Bill, Senate Bills number 28 of 2024, and seek leave to sit again tomorrow. As many as of that opinion say aye. Aye. As many as of the contrary opinion say nay. The ayes have it.
Mr. Speaker.
Tamefika. Proceed. Acha aende.
Now, honorable members, we are proceeding to report the progress of the Committee of the Whole, and I call upon the chairperson to report.
Thank you, Mr. Speaker, sir. I put the question that the committee... thank you, Mr. Speaker, sir. I beg to report that the Committee of the Whole has considered the Meteorological Bill, Senate Bills number 45 of 2023, and seek leave to sit again tomorrow.
Mover.
Honorable Speaker, I beg to move that the House do agree with the committee on the said report.
Somebody to second. Could be seconded, please.
I beg Senator Cherargei to second.
Honorable members, now I propose the question that the House do agree with the committee in the said report, and I put the question that the House do agree with the committee in the said report. Will as many as of that opinion say aye? Aye. Yes, will as many as of that opinion say aye? Aye. Will as many as of a contrary opinion say nay? The ayes have it. Okay, number 2, yes. Now we are proceeding to the next bill, that is the very well. The next bill that we are dealing with is the National Construction Authority Amendment Bill, National Assembly Bills number 59 of 2022, and I will call upon the chairperson to report.
Honorable Senator, Honorable Speaker, I beg to report that the Committee of the Whole has considered the National Construction Authority Amendments Bill, National Assembly Bills number 59 of 2022, and seek leave to sit again tomorrow.
The mover, Majority Leader.
Honorable Speaker, I beg to move that the House do agree with the committee on the said report. I request Senator Cherargei to second.
Honorable members, I now propose the question that the Senate do agree with the Committee of the Whole in the said report, and I put the question that the Senate do agree with the Committee of the Whole in the said report. Will as many as of that opinion say aye?
Aye.
Will as many as of a contrary opinion say nay? The ayes have it. We shall proceed to the third bill for consideration, that is the Cancer Prevention and Control Amendment number 2, Bill, National Assembly Bills number 45 of 2022. I'll call upon the chairperson to report.
Honorable Speaker, I beg to report that the Committee of the Whole has considered the Cancer Prevention and Control Amendments number 2 Bill, National Assembly Bills number 45 of 2022, and seeks leave to sit again tomorrow.
The mover.
Honorable Speaker, I beg to move that the House do agree with the committee of the said report, and I request Senator Chute or Shute to second.
I second, Chair.
I now propose the question that the House do agree with the committee in the said report, and I put the question that the House do agree with the committee in the said report. Will as many as of that opinion say aye?
Aye.
Will as many as of a contrary opinion say nay? The ayes have it. The next bill for consideration, honorable members, for reporting is the Election Offences Amendment number 2, Bill, Senate Bills number 28 of 2024. I ask the chairperson to report.
Honorable Speaker, I beg to report that the Committee of the Whole has considered the Election Offences Amendments number 2 Bill, Senate Bills number 28 of 2024, and seeks leave to sit again tomorrow.
Mover, Majority Leader.
Honorable Speaker, I beg to move that the House do agree with the committee on the said report. I request Senator Chute to second.
Honorable Speaker, I second.
Honorable members, I now propose the question that the House do agree with the committee in the said report, and I put the question that the House do agree with the committee in the said report. Will as many as of that opinion say aye?
Aye.
Will as many as of a contrary opinion say nay? The ayes have it.
We are busy doing the business.
Cross tu hakuna shida. When speaker.
So, honorable members, we will now revert back to the normal order as per the order paper, and the clerk, you call the next order. Actually, order number 8. Yeah, order number 8.
Order number 8, motion, report of the Select Committee on County Public Investments and Special Funds on its consideration of the audit reports of the water services providers for financial year ended 30th June 2019, 30th June 2022, and 30th June 2021.
resumption of debate.
Honorable members, when the House adjourned on the 12th of November 2024, Senator Osotsi, who is the mover of this motion, was to reply, and I now call upon Senator Osotsi to proceed to reply.
Thank you, Mr. Speaker. Mr. Speaker, first of all, I want to start by thanking the members who overwhelmingly contributed to this important motion on matters of water service providers. A number of issues came up, Mr. Speaker, which I would like to quickly address before I reply. There was the matter of late submission of documents, which is guided by Section 62 of the Public Audit Act, and this has become a problem where certificates for audit reports are issued by the Office of the Auditor General, and then when they appear before Senate committees of PIC and PAC, they carry big files of evidence. Most of those documents are questionable. So the matter of late submission of documents, we have agreed that moving forward, we will not accept evidence in form of documents which are submitted during the Senate hearing. Those documents needs to be submitted within the audit cycle. There was also the issue of how to mitigate the higher non-revenue, which in most counties is beyond 25%. And members felt that there is need to automate the metering system by having smart meters, and also the need to apply GIS solutions in terms of managing of water networks. There was also the common problem of errors in financial statements, which are attributed to capacity issues and training within the finance department. And Mr. Speaker, we have the Public Sector Accounting Standards Board that prescribes the format in which the financial statements should be submitted. And we have recommended that moving forward, all counties must align their financial statement to the Public Sector Accounting Standards Board. There was also the common issue of non-remittance of statutory deductions by these companies. And Mr. Speaker, this is a compliance issue and an offense. And we have directed that the counties involved to make sure that they submit their financial statements in time. The matter of transfer of assets and liabilities for these water companies was also a major issue, and IGRTC has been handling this matter, Mr. Speaker, but it's taking too long. I think it's important for these water companies to have their assets in their name so that their financial statements are not overstated. There was also the matter of declustering and clustering, which we reported that Bungoma and Trans Nzoia are now in the process of completing their declustering process so that they have separate water companies. The same applies to Kisii and Nyamira, Mr. Speaker. The specific issues, Mr. Speaker, that came up, for example, for Bomet County, was the matter of a project by the name Kenyareport water supply that is under which we referred to EACC for investigation, Mr. Speaker. There was also a serious problem with unlimited statutory deductions amounting to about 12.9 million. The issue of accuracy and recoverability of outstanding trade receivables amounting to 219 million. This matter, again, Mr. Speaker, has been referred to EACC for further investigation because we cannot have this huge amount of money not recovered and whose supporting documents are not available. The matter of the stalled Chebuntoyo Siogoi water project, which has stalled for many years, Mr. Speaker, amounting to 17.5 million. Again, this matter was referred to EACC. The matter of Gusii water, which is under Kisii County and Nyamira, we had a whooping 39.6 million as trade payables. Again, this matter, Mr. Speaker, we gave recommendations that this trade payables be reduced. The non-revenue water in this particular company is one of the highest at 46%, Mr. Speaker, with a wage bill of 69%. Kisumu Water, this is one of the most successful water companies, but aside, we have issues with internal controls, especially on the matter of exhauster revenues, how ticketing is done, and how the movement of the exhauster is managed, leading to loss of company funds. Unrealistic budgets and plans, and of course, high non-revenue water. Kwale Water, Mr. Speaker, also, the issue that was noted was a lack of budget control and performance, which resulted into a revenue shortfall of 40 million shillings. And also the high non-revenue water that stands at 57%. And again, the matter of unsupported debt with the Coast Water Services amounting to 180 million shillings. Mr. Speaker, Vihiga County, Amazi Water Company, it was noted that they have a long outstanding receivables of 63 million shillings and inaccurate trade and other payables amounting to 50 million shillings. This matter was noted and passed to EACC for further interrogation and investigation. Mr. Speaker, Nyeri County, this is Nyeri Water Company, which had debts totaling, outstanding debts totaling to 237 million, which has been outstanding for long. And again, this is linked to the Water Works Company. So, Mr. Speaker, I want to commend the members who participated in this debate and to say that this is the first report for water company that my committee has submitted to this House. We still have another 5 more motions to go on this matter. I hope we'll have those motions debated and adopted by this House before we go for recess, so that next year the committee can start handling the current issues, that is for the year 2022, 2023, and 2023, 2024, 2023, 2024, and 2024, 2025. Mr. Speaker, I want to commend my committee because this is the first report that a committee of Senate has tabled on matter of audit reports for water company. And I want to say that because of this, we are beginning to see some improvement in governance of water companies in our counties. But we still have challenges. The issue of ownership of this company, we have managed to ensure that almost all water companies are now owned by county government. Before, these water companies were either owned by crooks in our counties or people who are not county government. But through the intervention of this committee, I am happy to report that most counties have now complied. I am also happy to note that one of the water companies which was being run by private individuals in Murang'a, that is the Murang'a Water Company, and that is one of the most successful water companies, has now been reverted fully to the county government of Murang'a, and many, many other cases. So, Mr. Speaker, I know we are having cross-cutting issues that we identified. They are not necessarily audit issues, but that will be presented to this House in a separate report on matters of water management in our counties. Mr. Speaker, I do not want to go beyond that to say that I beg to reply and request that the putting the question be rescheduled to another date.
Standing order number 663.
Oh, you were asking me about Garissa. Garissa is in a different report, which is coming.
Yes.
Yeah.
A request for deferment of division.
Yeah, he has asked for it.
Oh,
Standing order?
You did it, 663.
Yeah, 66.3.
Thank you, Senator. It is so deferred. Next order.
Next one, order number 25. Mvua ama mvua? Is that rain? Kunanyesha? Rain?
yes, clutch. Is it raining?
Honorable Senators, I further rearrange the order paper so that we go to order number 25. Clerk.
Order number 25, the Elections Amendment number 2 Bill, Senate Bills number 29 of 2024, second reading.
Majority Leader.
Thank you. Mr. Speaker, I beg to move that the Elections Amendment number 2 Bill, Senate Bill number 29 of 2024, be number 29 of 2024, be now read a second time. Mr. Speaker, this is a very interesting legislation. I have been at the Bomas of Kenya in 2013, 2017, and 2022, Mr. Speaker. As an party, it's really unfortunate. In fact, I'm speaking like this, Mr. Speaker, because we've just watched elections in the first world. That elections were held. I'm speaking like this, Mr. Speaker, because we've just watched elections in the first world. That elections were held. More than 150, I think 130 million people voted, Mr. Speaker. And by 3, 4, 5 hours after that, you get an indication of who has taken the lead. They, in fact, if you have an interesting candidate like the President-elect of the United States, Mr. Speaker, he did not even wait for other states to declare the results. Once it became apparent, Mr. Speaker, that he was going to garner the magical 270 electoral college, Mr. Speaker, he went ahead and gave his victory speech. And the losing candidate also held back for a while, and eventually, less than 24 hours after the election, gave her concession speech, and life moves on, Mr. Speaker. In even more advanced democracies, Mr. Speaker, because a few months ago, I was in the UK when they were voting, and immediately, even on election day, you could hardly tell that there is any electoral process that is ongoing, Mr. Speaker. This intense litigation, agitation, and the fights that we have at Bomas, Mr. Speaker, are all a product of trust deficit. And the many legislations that we have passed here over the years in this House, most of the time, just a few days to election, Mr. Speaker, are to address some of these fears. And one of the things that I must appreciate about this bill that came out of, I must first declare, Mr. Speaker, that this is one of the so-called NADCO bills that came out of a negotiated dialogue process at the Bomas of Kenya where yours truly was part and parcel of the team that sat there, and we had representation from the Azimio coalition, Mr. Speaker, and the side of Kenya Kwanza, Mr. Speaker. And there are many things that we felt Kenyans, when they came and made presentations before us, they continue to raise about our electoral processes, Mr. Speaker. You listen to some of the proposed laws, Mr. Speaker, that are being added into our election laws. If you are not careful, Mr. Speaker, our election law book may end up being the largest in the world very soon, Mr. Speaker, by the very simple principle that we want to put it in writing, even the minutest of procedure, something that to other countries and to other people are rather obvious. But given that we are an extremely litigious country, and our judiciary doesn't help our cause, Mr. Speaker, because they agree even with people that you'd consider nuisance litigants, Mr. Speaker, who raise issues that are so mundane. But then, in typical fashion of our judiciary, sometimes, Mr. Speaker, they agree with them and they say, yeah, it's not written in law, it's not in our constitution, and therefore the petition has succeeded, Mr. Speaker. And therefore we ended up litigating on very minute details of our electoral process, as such that in other countries, Mr. Speaker, are not things that people contest or consider about, argue about, Mr. Speaker. But given that this is our home, we don't have another home. We are the people, there are no other people, Mr. Speaker. We have to learn to live the way we are accustomed to live with each other. And therefore, Mr. Speaker, in the various clauses that form part of this bill, there are actually about, 39 sections that are in this particular bill, Mr. Speaker. You will see and find yourself addressing many of the issues that have been of concern to Kenyans. And therefore, as we read about and give proposals in this particular bill, I hope that the House will eventually agree with us and put this in legislation. One last thing, Mr. Speaker, before I get into the details of the bill, that I appreciate about the genius of this legislation is that in all other elections, from 2017 and 2022, Mr. Speaker, we have fought in this House while trying to amend election laws, Mr. Speaker, a few months to the election time. Yet we know, if you read part of our election management processes, Mr. Speaker, what forms the basis of many of the electoral processes, Mr. Speaker, is a the so-called Kriegler report that came up after the disputed 2007 elections. And one of the so obvious and quoted phrases and recommendations in that particular report, Mr. Speaker, is the fact that we as Parliament were indicted for changing electoral management processes laws just a few months to the electoral cycle, Mr. Speaker, that we do deals last minute that make it impossible or difficult for election managers, Mr. Speaker, to conduct our elections to the satisfaction of the country. And you know very well, Mr. Speaker, that we have perhaps the highest standard of election expectation, Mr. Speaker, in comparison with the rest of the world. We expect a near-perfect process, let alone the fact that we know that it's run by human beings, Mr. Speaker, who many a times they enter these results deep in the night, having not slept for more than 3 hours, but we argue none the same, Mr. Speaker. And therefore, it is important to note that this time we have made the decision to make these laws more than 3 years before a general election, Mr. Speaker. And that is quite commendable, because it basically means, or about close to 3 years, Mr. Speaker, because it basically means that the Independent Electoral and Boundaries Commission, Mr. Speaker, will have sufficient time to acquaint themselves with all the provisions, Mr. Speaker, of our laws, as such that as they prepare to take the country into an election, Mr. Speaker, they will have learned of all our expectations, unlike has been the case previously, where we have amended election laws even 2 or 3 months before an election, and subsequently after that election gone ahead to fight and ask the IBC why they didn't do this or the other, of course ignoring the very obvious and basic fact that they did not actually have sufficient time to prepare. Let me get into the provisions of the bill, Mr. Speaker. Clause 2 of this bill proposes to amend Section 2 of the Act, which is election laws, Mr. Speaker, by providing for new definitions of terms of nomination, which is the term such as you insert, for example, a simple word. Remember what I mentioned earlier, that we argue even on some of the very basic things, that instead of just prescribing and saying that to vote you need a Kenyan passport, we want to propose it further and say that it must be valid, and therefore you have to put it in law. I don't think there is any other country where you'll find this in their legislation. But this is Kenya, like I've mentioned, and I've given a good history of how we find ourselves with this kind of arguments. And therefore, we want to make it clear in black and white that if you're using your passport as your primary tool of identification, then it must be valid. Rather too obvious for me, Mr. Speaker, but hey, that's who we are as a people. Let's proceed. Clause 3 of the bill, Mr. Speaker, is an amendment actually to Section 5 of our Act, which provides for registration of the voters. This is a point, Mr. Speaker, where there is a by-election. Another very, I lack the proper English vocabulary, Mr. Speaker, to actually explain this, but we have to do it anyway, because, like I have said, this is Kenya. You know, in Section 5 of the Act, Mr. Speaker, I'm not sure Senator Bodi Halwale has sufficient vocabulary for this as well. Neither does my good friend Crystal, actually, have. Because you know that when there is a by-election, Mr. Speaker, we freeze the registration of voters in that particular electoral area. And it's part of our election regulations, but there was need and the feeling that you must make it actually an issue of statute, not just regulation, so that people know that any time there is proposed to be a by-election in a particular area, you freeze registration of voters in that particular election, in that particular region, and actually provide clarity. Listen to this, Senator Crystal, that the restriction is only in the geographical area where that by-election is to take place. That's Kenya for you, Mr. Speaker. So you'll find that in 3A, we'll provide that the persons registered as voters during the period when registration of voters is suspended by a reason or by-election shall not be eligible to contest in electoral area affected by the by-election. Mr. Speaker, Clause 4 of the bill, Mr. Speaker, seeks to amend Section 6 of the Act, which provides for inspection of registration of voters. We are deleting subsection 1 and 2 and substituting thereof with new subsections providing for the inspection of register of voters by members of the public and rectification of particulars of voters, as well as exceptions when IBC shall not be expected to rectify the particulars of the voters. This is a usual process where they normally pin the list of registration or registered voters in a particular polling station, just providing clarity. I have pointed earlier that some of these things are either definition or we are going deeper into the law to just make it more appealing. Clause 5, Mr. Speaker, is amending Section 8A, which is a deletion of subsection 3 and provides for audit of register of voters by a professional, reputable firm for purposes of first general election after the commencement of this act. You know very well, Mr. Speaker, that we have argued about the validity of our register of voters. I don't know if in other countries they have this, Mr. Speaker. I know for a fact that you have come from observing elections, Mr. Speaker, in some land very far away from this place. I don't know in your conversations or in your exit report, they had any conversations about audit of the registered list of voters. And therefore, because we don't trust, or for some reason, we want to confirm, we have provided that a professional audit firm, upon the passage of this act, Mr. Speaker, we shall expect the IBC to conduct, Mr. Speaker, an audit of the register. You know, in other countries, Mr. Speaker, that's why our elections are extremely expensive, Senator Osoti. In other countries where you trust your independent institution, this is work that IBC on their own should have been left to do, you know, and clean it up. But of course, given the fact that we have provided, and remember the issue, you know, trust is an expensive affair. And I had explained why many of these issues actually stem from mistrust of the electoral process and the players in between.
You can imagine how much it will cost the IEBC to hire a firm to look into the list of registered voters. I think they're about 20 million, if I'm not wrong, or about thereabouts. Me and you and the Kenyan taxpayers will pay quite a tidy amount for that particular provision. But hey, let it be as it may. Clauses 6, 7, 8, 9, 10, 11, and 12 and 13 of the bill is an amendment of sections 14, 16, 17, 19, 22, 23, and 24, and actually 25, by deleting the word nominations and substituting it with registration of candidates so as to differentiate the role of IEBC and those of the registrar of political parties. Remember, there is a confusion in how the act presently is drafted where you cannot tell which is a part. Additionally, clauses 7 and 9 delete submission of party list in respect of parliamentary and county assemblies to IEBC by political, Additionally, clauses 7 and 9 delete submission of party list in respect of parliament and county assemblies to IEBC by political parties. Further, clause 10 of the bill proposes to delete section 22 and set out education requirement for a member of parliament or county assembly. These requirements, remember, have been declared unconstitutional in Wamboi and 10 others, but there's a Speaker of the National Assembly in Constitution Petition number 28 of 2021. So we're actually eventually removing those things that we're providing for education qualifications, Mr. Speaker, because you're saying you're representing people. And therefore, many of the people you represent, Senator Alwale, are not medical doctors like you. They have voted for you on account of they feel that you can represent them. And therefore, it was a feeling of Kenyans, and the courts have finally agreed with them. And I don't think we need to push this point further, that with regards to members of a county assembly and members of parliament, that they want to elect their own. The Bible says to each their own. If they feel that they want to elect a fellow who perhaps does not meet what we would know as at least a basic standard of a competent person to legislate and represent them, Mr. Speaker, like I've said, we are only humble servants of the people, and therefore we'll allow them to have it as they wish. Clause 14 of the bill proposes to amend section 27 by inserting a new subsection to provide that a coalition party shall within 14 days of registration submit to IEBC a copy of its nomination rules certified by the Registrar of Political Parties. Remember this issue of the coalition party. We argued here on the floor of this House about coalition political parties, and the same. I'm sure after the election, Senator Okongo Mugeni has since changed his views as opposed to what he had then because of the challenges that they had in trying to run as a coalition political party. You remember the debate that was here. But at that time, you are like me. What you accuse me of being nowadays is what you were at that particular time, Mr. Speaker. Clause 15 of the bill proposes to amend section 31, provides for nomination of political party candidates by deleting subsection 2, 2B, and 2C, 2E, and 2F, which provides that the IEBC shall, upon the request of a political party, conduct and supervise nomination of candidates by the political party for presidential, parliamentary, or county elections in accordance with Article 88 of the Constitution. It's just our feeling, Mr. Speaker, that there can be a time where political parties will have matured to the level, Mr. Speaker, of allowing the IEBC to actually conduct nominations for them, Mr. Speaker. And who knows, Mr. Speaker, if we were able to agree at the political parties level, Mr. Speaker, we could actually end up making it mandatory for all our political parties to do this, Mr. Speaker. But nonetheless, it's a decision of the political party. It's a right that you may not want to take it away from them. But we wanted to provide it in law, Mr. Speaker, so that if a political party feels that they don't have internal capacity to conduct a nomination process, Mr. Speaker, then they let it to IEBC. Of course, I know it will be a very costly affair. I know this, Mr. Speaker, because I have run nomination, Mr. Speaker, and participated in the management of nomination of a political party, the UDA, Mr. Speaker, that conducted nomination exercises in about, I think, 40 plus counties. It's a very, very expensive affair, Mr. Speaker. Part B is you submit to the IEBC the names and the person contesting the party primaries and the date of the party primaries for publication of this information in the Gazette notice. And you require also that the Parliament shall appropriate monies for the effective implementation of this section, Mr. Speaker. Such that basically what that means, Mr. Speaker, is that this exercise will be funded actually by the Kenyan public because they belong to these political parties. The only challenge is that we have provided the resources, but we have not made it mandatory for the political party to carry out its primary using the IBC. So the funds will be there, but it's the decision of the political party whether to use IBC or, Mr. Speaker, I am almost laughing when I remember about a certain political party that conducted their nomination electronically. And there was a big fight about password. Where is this password? I'm sure Senator Beatrice Ogola knows a thing or two about that password conversation that ensued actually in certain regions. So IBC has that mandate provided for in law, but upon the request of the political parties. Clause 16, Mr. Speaker, proposed to amend Section 32, which provides for the approval of a symbol for independent candidates by deleting the words nomination, day, and nomination, and substituting them with the words the date of registration and registration respectively. This is just about independent candidates and making sure that the process upon which they submit. Remember, when independent candidates want to submit a symbol which they are going to use in the election, Mr. Speaker, it's quite a long process. Clause 17 of the bill, Mr. Speaker, proposes to amend Section 33, which provides for the nomination of independent candidates. Mr. Speaker, just a few clerical things, ensuring that we clean that up. I don't intend to spend a lot of time on it. Clause 18 proposes to amend the Act by inciting new Section 33A to provide for publication in the Gazette of party candidates and independent candidates as registered to contest in a by-election. I said some of these provisions are rather too obvious, but we still must do the same. Clause 19 of the bill proposes to amend Section 34, which provides for nomination of party list members by inserting new Sections 8A and B to provide that a person can only be nominated as a member of a county assembly if such a person is a registered voter in a ward within a county. The person is to be nominated, and the need to ensure equitable representation from all wards comprising the respective county as regards nomination. Just providing clarity. Part of what Senator Crystal Lasige was trying to do last week or a few weeks ago, Mr. Speaker, by ensuring that all persons with disabilities, Mr. Speaker, alongside all actually marginalized groups, special interest groups, that's the right word actually that I was looking for, are nominated. Further to that, Mr. Speaker, there is a practice by political parties, and includes my own political party, of imposing people who are not resident of a particular county to form part of the members of a county assembly of that county. Mr. Speaker, I find to be completely unfair to the residents of that particular county. And therefore, I appreciate this new provision in law so that now it becomes abundantly clear that in nominating members of the county assembly, you can only nominate from registered voters of that particular county, Mr. Speaker. This takes away powers from the big boys of our political parties, but I feel it's a good provision. There have been, I know of stories, Mr. Speaker, and we've had petitions actually, including petitions brought to this this House, Mr. Speaker, where the only time a certain MCA was ever seen in a county assembly is the day when they went to take the oath of office. In fact, on the day of the swearing in, they were seen in certain towns asking for directions to the county assembly because they don't know even where the county assembly of that particular county is, yet they are members of a county assembly. So I want to urge members to support this so that political parties can only nominate voters from that particular county, Mr. Speaker. Clause 20 of the bill proposes to amend the Act by inserting new Section 38A to provide for designation of polling stations by IBC and publishing them in the Gazette at least 3 months before the date of any election. You know, we have argued before about creation of polling stations. Senator Eddie has a thing or two to say about this. Mr. Speaker, I read part of things he has said about against the IBC elsewhere. So we are making it now provided for in law, Eddie, that 3 months to the election, IBC must publish by Gazette notice the list of all the polling stations so that Kenyans know, they can check, and we don't have issues arising of saying, what was the name of that fellow? Jose Camargo created certain polling stations. Clause 22 of the bill proposes to repeal and replace Section 39, which provides for the determination and declaration of results, and substitute it with a new section. The new section proposes that results at the polling station shall be final, and the presidential election shall be tallied, announced, and declared, and electronically transmitted before all other elective positions. Further, the new section has omitted provisions providing for: 1, where there is a discrepancy between electronically transmitted and physically delivered results, the results which is an accurate record of results tallied, verified, and declared at the respective station shall prevail. B, any failure to transmit or publish election results in an electronic format shall not invalidate the results as announced and declared, because this is technology, things happen, Mr. Speaker. Part C is a requirement for IEBC to establish a mechanism for live streaming of results as announced at the polling station to facilitate public information, part of the public trust building mechanism, so that IEBC has part of its system, ways in which after the declaration of the presidential election result at Kapmaso Primary School in Kabianga Ward, where I vote, Mr. Speaker, I should be able to visibly check and confirm, because unless you have somebody who was at Kapmaso at the time of declaration of that result, Mr. Speaker, at Bomas, sometimes it's difficult to verify. Therefore, the easier thing to do is to make this information public so that I can easily check and confirm that if they announce that candidate X secured 400 votes, that is what is reflected on the IEBC portal. Clause 23 of the bill proposes to amend Section 44, which provides for technology to provide that the Commission shall ensure that the intellectual property to the technology is vested in the Commission. Senator Eddie should know why this forms part of that conversation. A supplier of the technology to be used shall not be found guilty of violating any procurement law or committed any crime anywhere in the world. Additionally, this is about open the server conversation, Mr. Speaker. And the 2017 one was the servers are asleep, Mr. Speaker, somewhere in France. This is part of addressing and providing clarity to that. Clause 24 of the bill proposes to amend Section 44, which provides for the complementary mechanism for identification of voters by inserting the words transmission of election results and mandating IBC to make regulations for better carrying into effect provisions of Section 44, part of what I had mentioned earlier. Clause 25 of the bill deletes Section 45, which provides for the conditions under which an MP may be recalled. These provisions were declared unconstitutional in the Katiba Institute and another versus the Constitution AG in the Constitution Petition number 209. Clause 26 proposes to delete the provisions of Section 46 1B, and that require the petition to recall a member of parliament must be signed by a petitioner who was registered to vote in the election in respect of which the recall is sought, and that the petition must be accompanied by an order of the High Court. These provisions were also declared unconstitutional, Mr. Speaker. Clause 28 proposes to repeal Section 74 of the Act, which provides for the settlement of certain electoral disputes by the IBC, since the mandate is now a function of the PPDT, Mr. Speaker, as provided in the Political Parties Act of 2011, Mr. Speaker, just providing clarity. 29 of the bill proposes to amend Section 75, which provides for the county election disputes by deleting the requirements that appeals to the High Court shall be on matters of law only, and inserting new section 5 to provide that the decision of the High Court on appeal on the validity of the election of a member of a county assembly shall be final. Clause 30 proposes to amend section 82 of the Act, which provides for the scrutiny of votes by providing that a court may extend a scrutiny of votes beyond the polling station or areas mentioned in the pleadings. Mr. Speaker, a rather obvious provision, but those who practice law in our courts like you, Mr. Speaker, know that this has been limited, actually the limitation of many election petitions, where perhaps given that election petitions are time-bound, Mr. Speaker, sometimes a lawyer either forgets sometimes a lawyer forgets, Mr. Speaker, to file in many of their contested election results, Mr. Speaker, and later on in the court process, they are denied the opportunity to provide for scrutiny, even when it becomes rather too obvious that an opening of a particular voting station, Mr. Speaker, will help the court in making the determination. Part 32, Mr. Speaker, clause 32 of the bill provides to amend section 85, which provides for appeals to the Court of Appeal in respect to members of the National Assembly, Senate, or the office of the county governor, by deleting the requirements that appeal shall be on matters of law only and inserting a new subsection 5 to provide that the decision of the Court of Appeal shall be final. I'm sure Senior Counsel Okongo Mogeni, who shall be seconding this and was part of the NADCO process, shall expound more of this. Clause 33 of the bill proposes to insert new section 87A, 87B, and 87C to provide for the appointment by Parliament of an independent firm to carry out an evaluation of the electoral process after a general election. The evaluation shall include the review of the legal framework, processes, and costs associated with the electoral process, and propose new provisions require preparation of a report and submission to Parliament within 90 days of the appointment of the independent firm. Just to ensure, Mr. Speaker, that at the end of every election, Mr. Speaker, we provided for a firm to audit the process in its entirety and lead Parliament in passing legislation such as this. Senator Ledama, you are not in the House, but I mentioned earlier that mistrust is what we are trying to cure in many of these proposals that are here. Otherwise, in other parts of the world, many of the proposals that are here will appear like obvious things. And therefore, to clean up our processes, what the bill is proposing is that after every electoral cycle, IEBC procures the services of an independent audit firm to audit the entire process from start in the preparation of the election to election day to declaration of results, and lead Parliament, including the cost of what it costs the taxpayers, Mr. Speaker, to run that election, and finally submit a report to Parliament so that Parliament can make independent decisions, Mr. Speaker, of how to further clean up our electoral processes, Mr. Speaker, or review certain costs or certain decisions that we have provided for in law that make it extremely expensive to run our elections. Remember, our elections cost are legendary, Mr. Speaker, and we have mentioned why this. Finally, Mr. Speaker, is a clause 33, which I have actually explained that particular clause 33. Therefore, as I conclude, Mr. Speaker, I wish to state that this is a very important bill, and therefore I want to urge honorable senators to support it. This is about what brings you to this House and the people that you represent. Elections are extremely important because they are the tools which forms actually the chance for the citizen to speak and exercise Article 1 of our Constitution directly, Mr. Speaker. Therefore, we are duty-bound as Parliament to provide and make it possible for them to exercise that constitutional provision with a lot of clarity. Senator, with those very many remarks, Mr. Speaker, Senator Okongo Mogeni was part of the NADCO team at Bomas of Kenya. NADCO 2, actually. I know Senator Ledama was part of the first one, and therefore has a good understanding as well of this bill. Therefore, I want to grant him the opportunity, Mr. Speaker, to second this bill. I thank you.
Before the senior counsel seconds your bill, Majority Leader, I would want to give you the comfort that part of what you said in the process of moving your bill is an inquiry as to a return or an exit report from the observation that we had with the elections conducted just in the United States of America. And the issue is about the trust deficit, which that report will speak to. And it will answer a number of the concerns which we are trying to cure in this particular bill. I would like to give you the comfort that the team indeed represented the House in doing what it was sent to do. Senator Olekina has confirmed that he was in NADCO 1, where yours truly was also a member, and so we participated in this process leading to the NADCO 2, where now I would like to ask Okongo Omogeni to second the bill. Senior Counsel, Senator Okongo Omogeni.
Yes, thank you, Mr. Speaker, for giving me an opportunity to second this bill that has been moved by Senator for Kericho. Mr. Speaker, for the record, you know, I went to a school that is in a village where Senator Kenyareport comes from, in Kabianga. So it's my pleasure to have served with him in NADCO. And Mr. Speaker, without the spirit of give and take, we will not have reached where we are today. So I want to thank him and the members that represented the UDA coalition for coming with a spirit of give and take. We did not get everything that we wanted as Azimio, and I'm sure that there are positions that were not representing the UDA coalition, but that they agreed to accommodate in the spirit of give and take. And Mr. Speaker, the spirit in NADCO was to ensure that when we go to the next elections, Mr. Speaker, the person who wins the confidence of Kenyans, the person who garners the majority of votes, Mr. Speaker, does not face a contestation in the Supreme Court. We hope, Mr. Speaker, we'll reach a situation where we'll have the person losing an election conducting himself like Biden. I think in the USA last week, within 2 days, President Biden, who was not a candidate, but whose party, the Democratic Party, had lost an election, placed a call to President Trump, who had won through the Republican Party, and said in a democracy there must be a winner and a loser, and he was welcoming him to White House so that he can assist in managing the transition. So I hope, senators, that you will support these amendments to the elections laws, which is trying to make it easy, make it transparent, and make the path to declaration of a winner in a presidential election much easier and more transparent. In fact, Mr. Speaker, one of the issues that was what is, I think, in clause, I think it's clause, in clause 39 of the bill. You know, Mr. Speaker, in the United States of America, you will start predicting the winner of a presidential election going by results coming from states. And Mr. Speaker, what this bill is proposing is that we now allow polling stations to have returning officers, so that if we are in Ikolomani, Mr. Speaker, by the time we are done with the counting and tallying of votes in that polling station, the returning officer will give final results and declare the winner from that polling station. So that by midnight, we should be getting results telling us, in Iborabu constituency, Boni Galwale, if he will be a candidate in 2027, I don't know whether he has presidential ambitions, it tells you Boni Galwale has taken Ikolomani. And if Senator Cheragei will be running for Gen Zs, we are told in Iborabu constituency, Senator Cheragei was number 3 or number 1. That is the spirit behind this proposed amendment, so that we don't need to wait for the commissioners in Nairobi to tell us who has won in Ikolomani. I mean, if even in Borabu, Mr. Speaker, we have tallied votes from all the polling stations, by the close of the day, we should see a 411 telling us that candidate A has taken Borabu. By the time we wake up in the morning, we should be knowing from all our constituencies, 290 of them, who is leading in a particular constituency. That makes the voting, the counting, tallying of results more transparent than what we have now, where you wait for officers to walk all the way to Nairobi before IEBC can declare who is a winner. So this is a game changer, honorable senators, that even if you want to contest a presidential election, you can narrow down to the polling stations that are contested. You don't need to sue the chairman of IEBC. You can actually select the few polling stations which are contentious, and you move to court challenging results from those particular polling stations. Mr. Speaker, also because of the high stake in presidential elections, we are making it mandatory that the first election that should be counted and tallied is the presidential election results. So if we close the voting in a polling station, Mr. Speaker, the first seat that should have votes counted is the seat of the president. Once it's done, you move to the county governor, senator, member of National Assembly, women, county women rep, and then you finish with MCA in that order. That's what we are proposing in this bill. It's all in the spirit of making it transparent so that we adopt the system that we see in the US, where by midnight you'll be told Trump or Harris has carried Florida. That becomes the end. Next, you'll be told Texas has gone to candidate X. And then the second thing, Mr. Speaker, is to adopt technology. What makes the results to trickle in as quickly as we saw in the US is because they are using technology, Mr. Speaker. If you employ technology, you get your results faster. I don't know what is the experience of honorable senators here, but in my seat, Senate Nyamira, I waited for 2 nights. 2, Mr. Speaker. Because people are doing manual counting, you wait for 2 nights. And if you are not sure about your victory, you don't even break to go and have a meal. You can't even go and have a bath. But if we embrace technology, we can do our tallying much faster, and we get our results almost the following day. Why should we vote on a Tuesday and you're being declared on a Thursday? That waiting is too long. So I hope when we get new commissioners in IBC, they will bring in technology that brings really change. In Brazil, you conclude elections and in the next 3, Senator Cheregei went to Brazil, I think, in the company of Governor Mutula, who was then Senator, Senior Counsel James Orengo, and they saw real time. But the problem in this country is that once people get positions, like you become a commissioner in IBC, you think more of how you're going to make money from that technology, instead of looking at bringing in a technology that will make the running of elections more efficient. If Brazil can use technology and declare elections within 3 hours, why not Kenya? Are we cursed? Mr. Speaker, are we a cursed country? And we use more money. If you follow, you'll find that we are paying more money for that technology than those other countries. And I've had Senator Sige telling me that even in the US, it took few hours. I think within 2 hours after the close of elections, results were trickling in. Really, we need, Mr. Speaker, when we get a chance to vet the new commissioners to IEBC, we should vet and ensure that the people who are getting a chance to serve in that commission are men and women of integrity, who can put public interest ahead of selfish interests of wanting to enrich themselves, Mr. Speaker. We don't want to hear those scandals we read some times ago about. Mr. Fully support the proposed amendment that makes nomination of county assemblies, as proposed in clause 19, to be people who are registered in those wards. The Speaker, the only thing we did not agree, and I hope we can find agreement, is that this should also be extended to our constituencies and our counties. If you are being nominated to represent a constituency in Starehe, Nairobi, you should ordinarily be a member who votes in that constituency, Senator Mutinda. If you are being nominated from West Mogirango in Nyamira, you should be somebody registered in that constituency. I've had agitation. Yesterday I was confronted by Senator Asige here, pitching that nominated senators should have money for county operation offices. If you need that money, Mr. Speaker, we should ensure that you come from that county. Because if you get money to run your office, it should be Senator Mutinda, Nairobi, running our office in Nairobi. Senator Asige from Mombasa, running our office in Mombasa. Senator Beatrice Oyomo from county of Homa Bay, having an office in Homa Bay, running our county office in Homa Bay. Ordinarily, you should be somebody who votes in that county or in that constituency or in that ward. So I'll be maybe asking senators, honorable senators, to reconsider whether clause should be extended so that we don't just say MCA voting in that ward. Let us extend that spirit, that intent to be applicable also in constituencies and in our counties. I think it's a fair thing to do. The other point I want to make to contribute on, Mr. Speaker, is the issue of appointing polling stations, as proposed in clause 20, which is amending section 38A. Mr. Speaker, I was privileged in 2017 to be one of the lawyers who was appearing for Honorable Raila Amolo Odinga in a presidential election petition. And you know, Mr. Speaker, some of the issues that crop up in that election petition is a situation where returning officers would tell us that I decided to set up a polling station in a certain place because nomads had moved. There were no people in the designated polling station. I mean, we can't do that. Polling station should be known by voters. So what this amendment to section 38 is proposing is that IEBC must appoint a place that is publicized and that is known to the voters. So if we're in Nairobi and you say polling station is Starehe, and for example, that should be what the voters in that constituency know, and that's where they should go and vote. If you are in West Mogrango and you say one of the polling stations is Girigiri Primary School, that should be gazetted, publicized, and known to the voters. We should not have a situation where capriciously Electoral Commission officials can set up polling stations that are not known to anybody. 3, Mr. Speaker, as you know, you practice as a lawyer, and we have had serious problems with time. If you are doing a presidential election petition, Senator Cherargei, you know the time within which you must sit, sift through cartons of documents, prepare your petition, and file. And then when you appear before the Supreme Court, they will tell you, you cannot do scrutiny in a polling station that you did not name in your presidential election petition. Lawyers are also human beings, Mr. Speaker. We are not machines. So we are giving leeway to the election petition courts to look at issue of allowing scrutiny in polling stations beyond the time that is given, so that you don't need to restrict a council and say, if you didn't name your polling stations where you need scrutiny within 7 days, we will not allow you. We want to give our judges an opportunity to hear lawyers, exercise judicial discretion, and if they think a basis has been laid, then they can extend time and allow scrutiny. The spirit of Article 159 of our Constitution is to do substantive justice and not pay undue regard to technicalities of procedure. I know those who practice law in this House, like you, Mr. Speaker, you understand how important this particular amendment will be to lawyers. Then they proposed amendments to Section 82, access to information including technology used in an election. You know, we are trying to cure the problems that we all saw during the election petition that was filed ensuing from the 2022 general election. In 2017, Mr. Speaker, if you remember, the Supreme Court issued an order for that technology to be released. We were told the lawyers in France had not woken up. When the lawyers in France woke up, we were told the technology is also hosted in USA. The lawyers in USA were asleep. We waited till 8 p.m., which is in the US was about midday. Still, technology was not availed. So we are making a proposal here, Mr. Speaker, that the Commission should ensure that there is access of information, including any technology that is used in an election. Because, Mr. Speaker, this is public money. When we are employing technology, we are using taxpayers' money, Mr. Speaker. And we want Kenyans to have easy access to information so that everything is transparent. The spirit in Articles 80, 81, 82 is that our elections should be transparent, they should be very viable. There is no way an election can be very viable if we are not making technology available. That is in the spirit of making Kenyans to have faith and confidence in an electoral process. It was our prayer in Article, Mr. Speaker, that in 2027 elections, we should not have a dispute. Everything should be so transparent that at the time we conclude the elections and a candidate is declared, every Kenyan should accept that truly that is the choice of the people. The other problem, Mr. Speaker, and I'm sure most of us who are candidates have experienced, is the issue of delay, which is being addressed in clause 39. The proposal there is that each polling station should have a returning officer, and once you tally the votes, you make a declaration. But there has been a problem before. You know that you can have a polling station that is the closest to the constituency tallying center. But there can be delay, unreasonable delay, in releasing results. You finish counting even at 8 p.m., but the presiding officer will tell you, I'm not able to announce results till the following day. What we are proposing here, Mr. Speaker, if you read clause 4, we are saying that the results should be tallied within 2 hours. Within 2 hours, results should be released, everything fed into the electronic system, and everybody has access to the results. And if you delay, there should be consequences. If you unreasonably delay announcement of results, there should be consequences. In 2013, I did an election petition for a candidate in an election in Nyaribari Church. And Mr. Speaker, while we were looking through the transmission of results to the tallying center at Gusii, we discovered that the polling station that was closest to the tallying center was the last one to declare and transmit results, Mr. Speaker. And when we requested the court and the court ordered scrutiny, Mr. Speaker, we found that there was a lot of tampering of results from that polling station. So at times, presiding officers delay release of results deliberately so that they can manipulate the results, interfere with certain documents, okay, before the results are announced. So this idea of giving the presiding officers and the returning officers time is to ensure that there is no opportunity given to the presiding officer or to the returning officers to manipulate the outcome. As I conclude, Mr. Speaker, I know we have not prescribed in these amendments that IEBC should assist political parties in carrying nomination. But, Mr. Speaker, I think time has come for political parties to allow IEBC to conduct nominations for parties. There are many regions in this country, Mr. Speaker, where nomination means everything. If you win, you are as good as a member of parliament.